He was born on November 29, 1816 at Lyme, Connecticut. His dad is Henry Matson Waite, an attorney, and his mother is Maria Selden. His father was later appointed Judge of the Superior Court and Associate Judge of the Supreme Court of Connecticut. He married a woman named Amelia Chamberlain Warner on September 21, 1840, in Hartford, Connecticut, and they had 4 children. He graduated from Yale University in 1837 to read law and began to practice in Mahoning, Ohio, moving later to Toledo. Shortly after graduating, Waite became a law clerk for his father. Shortly after graduating, he was admitted to the bar in 1839, and he was elected to one term as mayor of Mahoning, Ohio. After the death of Chief Justice Simon P. Chase, President Ulysses S. Grant nominated Waite in January 21, 1874. He became the 7th Chief Justice for the Supreme Court and served for the next 15 years. He was then sworn in on March 4, 1874, and Waite's service was terminated on March 23, 1888 due to his death. Waite concurred with the majority in the Head Money cases, the Ku Klux Klan case, the Civil Rights cases, Pace v. Alabama, and the legal tender cases. Among the most important opinions he personally wrote were the Enforcement Acts cases, the Sinking Fund cases, the Railroad Commission cases, and the telephone cases. His political party was Republican. He helped establish the legal concept of the corporate personhood in the United States, and his religion was Episcopalian. He died of an unexpected pneumonia, and Waite's most famous decision was Munn v. Illinois. It was a case in which the United States Supreme Court upheld the power of government to regulate private industries. Chief Justice Morrison Waite spoke for the majority when he said that state power to regulate extends to private industries that affect the public interest. He was a skillful administrator of the nation's highest branch, and in 1870 he was known as the best lawyer in Ohio. And this is the official Chief Justice nomination document.
Hi, I'm Cameron, and the Supreme Court case we worked on was California versus Greenwood. Who was involved in the case? Jenny Stranner, Billy Greenwood, Diana Van Houten, and William Rehnquist. When did the case happen? It was argued January 11th, 1988, and it was decided May 16th, 1988. Where did the case originate? It originated in a state appellate court. What happened in the case? Police officers had information that Greenwood was involved in illegal drug transactions. The police had garbage collectors empty his truck and then go pick up Greenwood's trash. The evidence from Greenwood's trash was offered as probable cause to support the issue of a warrant. The search of Greenwood's home yielded evidence that led to Greenwood's arrest on drug charges. The trial court concluded that search of a person's trash violated the Fourth Amendment and the California Constitution. The trial court dismissed the charges against Greenwood. Why did the case go to the Supreme Court? The state of California appealed, and the Court of Appeals affirmed the district court's dismissal. The state Supreme Court declined to review the appellate decision. The states petitioned the United States Supreme Court for review. What was the decision by the Supreme Court? Voting 6-2. The court held that garbage placed at the curbside is unprotected by the Fourth Amendment. Yes, I know it says 6-2, and there's supposed to be 9 judges overall, but Justin Kennedy did not take part in the case, so there you go. That's why it's 6-2. You're welcome. What was the impact on American society? Today, California versus Greenwood still provides the basis of warrantless police searches of trash. The ruling followed in the footsteps of previous court decisions which sought to narrow the right to privacy. Thank you for listening, and have an amazing day.